The proceeding will start shortly. 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 The proceeding will start shortly.
Order, order. Good afternoon. Before we begin, could I draw everyone's attention to the guidance issued by the House of Commons Commission in terms of safety and ask everyone to be considerate to others and to keep your distance where possible. Thank you all very much. We now move on to the debate for this afternoon, and I call Christina Rees to move the motion. Christina Rees.
Thank you, Mr. Rosendale, and it's a pleasure to see you in the chair this evening. I beg to move that this House has considered E-petitions 323926 and 575620 relating to road traffic offences for fatal collisions. The first petition, started by Louise Smythe and Helen Wood, titled Tougher Sentences for Hit-and-Run Drivers Who Cause Death, opened on the 20th of July 2020 and closed on the 20th of January 2021, and received 104,324 signatures. It states that the maximum penalty for failure to stop after an incident is points and a 6-month custodial sentence. Causing death by careless or dangerous driving is between 5 and 14 years. The sentence for failing to stop after a fatal collision must be increased. Our sons Matt, aged 25, and Paul, aged 23, were both killed on their motorbikes, just 9 months apart. Both drivers fled the scene. We are not the only families to have suffered this tragedy or endure unjust sentencing. We at the Roads Injustice Project want the laws changed, as we feel they are both outdated and unfair. Tougher sentences are needed for the life sentence we have to deal with every single day, from the loss of our sons due to the actions of somebody else. On the 28th of August 2020, the Ministry of Justice responded to the petition and said that it is wholly irresponsible for drivers to fail to stop and report an incident. However, the offence of failing to stop should not be used to punish an offender for a serious but not proven offence. We were very sorry to read of the deaths of Matt and Paul. Our sympathies are with their families and friends. Failure to stop and report offences are often referred to as hit and run, but this is not an accurate reflection of the offence. The offence is designed to deal with a behaviour relating to the failure to stop, not to provide an alternative route to punish an offender for a more serious but not proven offence. The second petition, started by Leanne Salton, titled Ryan's Law, widened definition of death by dangerous driving, opened on the 2nd of March 2021 and closed on the 2nd of September 2021. And received 167,470 signatures. It said that the offence of causing death by dangerous driving should be widened to include failure to stop, call 999 and render aid on the scene until further help arrives. A hit-and-run driver left my brother Ryan in the road and he died. Hiding for 36 hours, charged with failure to stop, the driver received a suspended sentence and a fine. Failure to stop or careless driving offers lighter custodial sentences and focuses on fines or suspensions. Drivers should stop, ring 999 and render aid until help arrives. If they do not, they should face charges for death by dangerous driving. The law should require this and aim to reduce the number of hit-and-runs and roadside deaths. With this definition, a minimum 10 years to a maximum life sentence, citizens should be better protected. On the 24th of March 2021, the Department for Transport provided an identical response. Apart from, ministers are aware of the tragic circumstances surrounding the death of Ryan Salton and extend their sympathy to family and friends. But they did add that the government takes this issue seriously. The Department for Transport is looking into the issue of such incidents of failure to stop, resulting in death or serious injury, and exploring whether there are further options that can be pursued. It is no surprise that those in favour of a change in the law say that there is a perverse incentive for a driver who is under the influence of drink or drugs to leave the scene of a traffic collision, thereby avoiding a drink and drugs test by the police. If they hand themselves in to the police later, they cannot be tested because of the time that has lapsed and are likely to avoid a more serious offence or penalty. I met with all the petitioners virtually last week and listened to their heart-breaking stories, which reduced me to tears. I cannot imagine the pain they have gone through and are still going through. They have come to Parliament today, and I met them again this afternoon, and they are in the public gallery this evening. I cannot pretend to understand the depth of their grief, but I commend their courage and their tenacity in wanting something good to come out of their grief. On the 29th of August 2018, Matt Smythe, aged 25, left his girlfriend's house at about 3 a.m. and was driving along the A1307 on his motorbike, heading home, when he was hit by a delivery van that pulled out of a side junction into Matt's path. The driver stopped briefly at the scene, but then drove off, leaving Matt lying in the road. A passing HGV driver found Matt about 25 minutes later. The driver who had collided with Matt came to a stop a few miles up the road and telephoned his employers. He told his company that he had hit a deer and that his van was damaged so that it couldn't be driven. The company arranged for him to be sent a new van, and he continued on his delivery round before going home and going to bed. The police caught up with the driver, Mr. Richard Tarasca, later that day when he was still asleep in his bed. Mr. Tarasca was charged with causing death by careless driving and failing to stop after a collision. The prosecutor said that it was inconceivable that the driver did not realise that he had hit a motorcycle because Matt was thrown onto the van's bonnet and he had to manoeuvre around Matt's body and motorcycle. Mr. Tarasca was sentenced to 14 months, of which he served only 5 months and was disqualified from driving for 31 months. The judge said that it was a grossly irresponsible act to not stop, and driving around Mr. Smythe's body and the wreckage of the motorcycle was inexcusable. On the morning that Matt was killed, he was due to attend his first midwife's appointment as a father-to-be. Matt never lived to see his daughter, who is now 2.5 years old. Matt's father had also been tragically killed in similar circumstances 18 years ago, whilst he was driving his motorcycle. Matt's best friend Paul was 23 years of age when he was killed 9 months later. Paul left for work on the 24th of May 2019 at 6:45 a.m. on his daily motorbike drive to work. He was hit by a Range Rover that pulled out in front of him. The driver, Mr. Cooksey, got out of his vehicle and lit a cigarette. A witness at the scene spoke to Mr. Cooksey and noticed the smell of alcohol on his breath. But he ran away and hid behind some trees before walking to Cambridge train station, where he got into a taxi cab to go to a pub in Romford where he lived. He drank 8 pints of lager before handing himself into the local police station that evening, and he couldn't be breathalyzed because he was intoxicated. Paul was pronounced dead at the scene. Mr. Cooksey had been disqualified from driving the previous month and had previous convictions for drink driving and driving whilst disqualified. He admitted drinking heavily the evening before until about midnight and said that he was driving his car at about 5 a.m, but this couldn't be proved because he had left the scene and continued to drink until he handed himself in to the police. The judge said that the driver was devious and untrustworthy with a bad record for driving offences that have resulted in disqualification and prison sentence, and that no sentence would ever reflect the loss of a human life. Mr. Cooksey admitted failing to stop at the scene of the collision and was found guilty of causing death by careless driving, causing death while disqualified from driving, and causing death whilst driving uninsured. He was sentenced to 3 years imprisonment, but will serve half or less. And he was also banned from driving for 4.5 years. Paul's family told me that they have not been the same since Paul was killed. They are living a life sentence. But the criminals on our roads are not punished in accordance with the crime. Our loved ones need to be recognised as a human being and not a wing mirror or a bit of metal damaged in a road traffic collision. The hit and run or leaving the scene sentencing guidelines were put in place many years ago, and these need updating to encourage drivers who have caused a collision to stay and get the help needed for the victim, which could potentially save the lives of hundreds of victims on our roads every year. Ryan Salton, a postman, a husband, a father of young children, was killed in the early hours of the 28th of July 2018 when he was walking to a party along the single-track B3267 after being hit by a driver who did not stop. Ryan's body was dragged beneath the car and he died of catastrophic injuries. The driver made no attempt to stop, and Ryan was subsequently left in the road to be discovered by the next passing vehicle. The forensic investigation proved it was a failure to stop that caused the injuries relating to Ryan's death. The driver, Mr. Wayne Schilling, was identified some 36 hours later when he was reported to the police by his own father. A blood test was taken which proved negative for alcohol due to the time lapse, and it was too late to conduct a toxicology test. Mr. Schilling admitted failure to stop and report an accident whilst driving home from a carnival. Witnesses said that he had been drinking at the carnival before he drove home. Mr. Schilling told the police that he felt a slight bang and did not realise that he had hit anyone, but the collision was found to have punctured his car radiator. Mr. Schilling received a sentence of 4 months, suspended for 12 months, disqualified for driving for 12 months, given an evening curfew for 4 months, and ordered to pay a £207 victim surcharge and prosecution costs. Ryan's family believe that the law does not protect the victim of crime, but protects the criminal. And it is a total injustice to Ryan. Whilst Mr. Schilling chose not to answer questions leading up to and after the trial, at the coroner's inquest he admitted to drinking 4 cans of alcohol before hitting Ryan. He has never displayed any remorse whatsoever to Ryan's family then or since, and he taunts them. Ryan's family believe that when a driver hits a person, they should stop, ring for help and remain on the scene, rendering aid where possible, appropriate and necessary, as instructed by emergency services. When a driver does not do this, they should be considered a dangerous driver and a minimum sentence should be set, ultimately encouraging drivers to stop after collision. Stopping at the scene will help to save lives and identify those genuine accidents from those that leave the scene to protect themselves. There are many more cases like Ryan's, with drivers escape injustice by not stopping at the scene. I also met virtually with Alison Hernandez, the Police and Crime Commissioner for Devon, Cornwall and the Isle of Scilly, and the Road Safety Lead for the Association of Police and Crime Commissioners. Alison launched a strategy in 2018 to create the safest roads in the UK. An APPC road survey conducted in 2020 received 66,266 responses from across England and Wales. 81% believed that road offences required more enforcement. But this is not the first time that these life and death issues have been debated in Parliament. On the 8th of July 2019, the former member for Warrington North moved E-petition 236952, Violet Grace's Law, for life sentences for causing death by dangerous driving, in memory of 4-year-old Violet, who was tragically killed when a stolen car was driven at 83 miles an hour in a 30-mile-an-hour zone. Violet's nan was with Violet, and she suffered life-changing injuries. The driver and his passenger did not attempt to help Violet and her nan. They fled from the scene, and there is evidence that they had to step over the bodies of Violet and her nan lying in the road when they got out of the stolen car. The driver not only fled the scene, he fled the country. He went to Amsterdam. And when he eventually returned, he and his passenger were sentenced, but served less time in prison than Violet was alive. For people who have to have confidence in the law, it has to protect the innocent, punish the guilty, and deter further offences. But families believe they have not had justice, with the imposition of unduly lenient sentences. The offence of causing death by dangerous driving was not introduced until the Road Traffic Act 1991, but even then there were widespread complaints that the CPS was often charging people with lesser offence of careless driving because it was felt that it was more likely to lead to a conviction. In 2003, the maximum sentencing for causing death by dangerous driving was increased from 10 years to 14 years. The Road Safety Act 2006 introduced the offence of causing death by careless driving and causing death by driving whilst unlicensed, disqualified or uninsured. The Legal Aid, Sentencing and Punishment of Offenders Act 2012 introduced the offence of causing serious injury by careless driving, punishable with a sentence of up to 5 years. The Criminal Courts Act 2015 introduced the offence of causing serious injury whilst driving whilst disqualified, punishable by 4 years imprisonment and a fine. In October 2017, following a consultation in which 70% of respondents thought that the maximum sentence for causing death by dangerous driving should be increased from 14 years to life imprisonment, the government announced that they would do so when parliamentary time allowed. A one-clause bill would have had widespread support across the House and from the public, but the government failed to find any parliamentary time then and since. Nearly 3 years later, on Tuesday the 21st of July 2020, the former Prime Minister, the Right Honourable Member for Maidenhead, introduced a bill into the House to amend the Road Traffic Act 1988 to increase the maximum sentence for causing death by dangerous driving to life imprisonment and for connected purposes. And she said that the phrase dangerous driving is an all too familiar phrase that does not reflect the tragedy and devastation of lives that lie behind it. She told the House about her constituents. 19-year-old Brian E. Hollands, who died at the hands of a dangerous driver and the influence of drink and drugs, and was sentenced to 8 years, but served 4. Kira Lee's husband Eddie, who was killed on the M4, and the driver was sentenced to just 22 months. And 13-year-old Max Simmons, who was hit and killed by a driver under the influence of drugs. Her bill was short, specific and targeted, and would retain discretion for judges to decide what length of sentence is appropriate, provide greater scope and enable more severe sentences, and does the government's work for them. The latest statistics provided by the House of Commons Library show that the current law does not cope with these offences. In 2020, there were 2,467 prosecutions and 1,889 convictions for failing to stop or report a road traffic accident. And the most common sentence was an average fine of £289. A small number received custodial sentences, the average being 3.6 months. In 2020, there were 184 prosecutions and 154 convictions for causing death by dangerous driving. And the most common sentence was immediate custody, with an average sentence of 4 years and 7 months. In September 2020, the government produced a white paper. Clauses 64 to 66 proposed to increase the maximum penalties for causing death by careless driving whilst under the influence of drink or drugs, and for causing death by dangerous driving from 14 years to life imprisonment, and created a new offence of causing serious injury by careless driving. The Police Crime Sentencing and Courts Bill is currently going through Parliament. My honourable friend, the member for Exeter, moved an amendment, New Clause 20, in the Commons on the 5th of July 2021, which proposed a maximum sentence of 14 years where a driver fails to stop and exchange details or report the accident to the police in cases where they knew or ought reasonably to have known that a serious or fatal injury had occurred or might have occurred. The Lord Chancellor said more work needs to be done to identify that class of driver who manipulates the system and evades responsibility in a way that outrages the community and offends the wider public. On November the 8th, at the committee stage in the House of Lords, the Right Honourable Lord Paddock moved Amendment 161, which had very similar wording to New Clause 20. Lord Paddock stated that 6 months may be appropriate when someone drives off after scraping the paintwork of someone's parked car, but not when someone is left dead by the roadside.
Thank you. My 31-year-old daughter Jenny was hit by a car just over 100 yards from my house 13 months ago. The driver drove off, came back to look at the scene and drove off again. My daughter died 9 days later. The driver received a 12-month custodial sentence for careless driving, but is now appealing that sentence as it is, I think she believes, disproportionately hard. Does my honourable friend agree that at the very least, sentencing guidelines need a full and thorough and substantial review to assure families left bereft that justice is done?
I thank you, my honourable friend, my dear friend, for his intervention. And sometimes words are not enough to express what you must be going through, what you've been through. And I completely agree. I completely agree. Lord Paddock moved new subsections to Section 170 of the Road Traffic Act 1988 to cover hit-and-run collisions, and mentioned the petitions we are debating this evening. And he said that they highlight the inadequacy of the existing legislation. Baroness Jones of Moulscombe spoke in support, calling hit-and-runs a menace, and that judges should have available a range of sentences to reflect the severity of the offence, and there should also be a lifetime driving ban for a hit-and-run driver fleeing the scene and cowardly trying to escape justice. It's a life and death situation for the person who has been hit. Baroness Williams of Trafford, responding for the government, gave the standard response which we have heard so many times this evening, and said that her ministerial colleagues at the Department of Transport understood the concerns that have been raised and are exploring options, including available penalties and how the offence operates as part of long-term and wider work on road safety. And it was on that basis that Lord Paddock withdrew his amendment. The petitioners and many more families who have lost loved ones in road traffic collisions don't want any more warm words and empty rhetoric from the government. They want the law to be changed. I have read a portfolio compiled by Leanne Salter of hundreds of families who have contacted her after losing a loved one in similar circumstances to the petitioners. It made me cry. No sentence will ever make up for the tragic loss of a loved one, and families have been constantly told that reform will be introduced when parliamentary time allows. Mr. Rosendale, the time is now. Will the Minister urge his government to change the law as set out in these petitions? And will he meet with the petitioners and other families to give them the opportunity to be heard? For they must be heard. Mr. Rosendale.
The question is that this House has considered E-petitions 323 and 926 and 575620 relating to road traffic offences for fatal collisions. Sherilyn McCrory.
Thank you, Chair. It's a pleasure to serve under your chairmanship, and I'm pleased to be called in this extremely important debate, and it's one that I've been anticipating for quite some time, and I congratulate the Petitions Committee for bringing this forward. And first of all, I want to pay tribute to Ryan and Ryan's family, who are here today. Ryan lived locally into Cornwall and from my constituency with his wife and son, and worked in Truro, I believe, as a postman. I wanted to also thank the 270,000 people or more who signed the two petitions, and specifically the nearly 4,000 signatures from across my constituency, and I believe it was something like 14,000 across the Devon and Cornwall police area. As we've heard, Ryan was killed in an incident on the road in which the driver left the scene and did not report the incident for 36 hours. In fact, he didn't even go in of his own accord then. The driver had been seen drinking that evening and later admitted to failing to stop and failing to report the accident, and the punishment, as we have heard, woeful. There is no question that this punishment did not fit the perceived crime, and it has led to the campaign by Ryan's family. They have been campaigning for tougher sentences for those who fail to stop and report an accident, and they've set up the petition calling for Ryan's Law, in which the definition for death by dangerous driving would be widened. I know that my honourable friend, the member for North Cornwall, who's here today, has been working incredibly hard on this, and he will agree with me about the importance for the need for change. We've been working towards increasing the sentencing range for failing to stop and report an accident. Both he and I have had meetings with transport ministers over the past few months, as well as the former Secretary of State for Justice, to discuss Ryan's Law specifically. I'm pleased that the member for North Cornwall is here today, and I know that, like myself, awaits interest the Minister's update on this matter. Back in July, the wind-ups addressing the representations around the specific law change for third reading on the Police, Crime and Sentencing and Courts Bill, the Lord Chancellor at the time said, "My ministerial colleagues at the Department for Transport are working to explore options with the officials about how these offences will work in the wider context. But since then, I know that the Department for Transport has been working on an options paper and have highlighted the complexity of the area, that this has brought up issues that will require further investigation to fully assess the potential impact of any legislative changes." and I know that the Department of Transport has been seeking external views to ensure that any changes are done correctly and are considering this as part of a plan for a wider call for evidence on road traffic matters. I do appreciate that the meetings and work that the Minister and the Ministry for Justice and the Department of Transport have given to MPs like myself and the member for North Cornwall. And I do understand the complexities around the specific demand on the law change. However, we've heard, and we'll continue to no doubt hear about tragic cases like Ryan's, where the punishment does not fit the crime. I read Ryan's petition, and it took me some time, and I was incredibly moved by the number of stories similar to Ryan's, and it is an emotional thing to read. I'm sorry to say this is not an unusual situation, however shocking these stories are. I'm afraid to say they are all too common, and we must do something positive whilst we have the opportunity to do it. We just cannot keep the status quo. It leaves grieving families like Ryan's and other families bereft of justice, and we are better than that. I hope that we are better than that as a whole society, and I know that we are better than that as a government. I hope that the department is genuinely actively considering on working towards getting this vital law change and how we can do that to ensure that those that fail to stop and report the accident properly face the punishment that fits the crime.
Ben Bradshaw.
Thank you very much indeed, Mr. President. It's a pleasure to serve under your chairmanship, and I'd like to congratulate those petitioners who have brought this subject to Parliament for debate, because I think this reflects a growing concern in the country and indeed in this House about how increasingly, when it comes to road crime, the punishment, as we've heard, does not fit the crime. Offenders all too often get off with a paltry fine, a suspended sentence, or a ridiculously short driving ban, if they get a ban at all, while the loved ones of the victims are left devastated and grieving for the rest of their lives. And this debate, as we've heard, is particularly timely because the government's police crime sentencing and courts bill is going through the House as we speak. And this is an opportunity for the government to address these concerns, put right these injustices. But I'm afraid to say, so far, I have seen little evidence, apart from the warm words, that they are serious about doing so. They are recommending a number of changes to some of the penalties, as we have already heard, and these may go some way to address some of the historic concerns around road safety and road crime, depending on how they are implemented. And they may deal with some of the most egregious road crimes. However, they do not do anything to tackle a much larger number of fatal and serious injury cases that don't always attract the headlines and which treats careless driving that is actually dangerous, is over-reliant on prison sentencing rather than driving bans, and allows offenders all too often to escape a ban by pleading exceptional circumstances, as well as limiting severely the sentences for causing serious injury rather than death. Now, in my view, the government could very easily do three things, and I hope it will, to go a lot of the way to address some of the concerns of the families who are here today and the concerns more widely. Firstly, it could bring forward the full review of road traffic offences and sentences that it promised nearly 8 years ago. Not the partial review that was referred to in the House of Lords last week, not the limited proposals that we've seen coming forward in this bill. We were promised by the former Justice Secretary nearly 8 years ago a full review of road traffic offences and sentences. We need that, and I would ask the Minister where it is. Secondly, as we've heard, the government could address the scandalously low maximum sentence for hit and run. I mean, I don't think many people out there realise that the maximum sentence for hit and run is, or for leaving the scene of an accident, is 6 months in jail. And as we heard from the Lord Panic in the other place, that might be appropriate if you've scratched somebody's car. It is not appropriate if you leave somebody seriously injured or dying in the road, often with the motive of getting off being tested for drink or drugs and getting away with the crime altogether. And I haven't heard a convincing argument for the government as to why they can't adopt my amendment to increase this offence considerably. If there is one, I would like to hear it. I don't accept the argument that this would be a way of prosecuting people unfairly for accidents that they weren't responsible for. Leaving the scene of an accident, leaving someone when you know you've hit someone who is probably seriously injured or dead, is a serious enough offence in itself to warrant a longer sentence than 6 months. And we've heard some of the tragic cases, but there are many, many more cases we don't hear about. Hit and run cases have increased exponentially in the last 10 years, and we really do have to do something about this. The third thing, which I hope the government will look at again, are exceptional circumstances and the way that far too often drivers get away without a driving ban by pleading exceptional circumstances. I'll give you one particular case which in my view, sums this up very well. When cyclist Lee Martin was killed by Christopher Gard in 2015, it was the 9th time in 6 years that Gard had been caught using a mobile phone while driving. He'd been convicted 6 times, fined and sent on a driver retraining course, but he'd escaped a ban, pleading exceptional circumstances, before going on to kill Lee. He should have been disqualified, Mr. Rossendale. In the last 10 years, 80,000 cases have occurred where road criminals should have received a ban but have been let off pleading exceptional circumstances. Courts have accepted as exceptional circumstances the need to do the school run, the effect it might have on a relationship. This is bringing the law into disrepute, I would suggest, Mr. Rossendale, and the government should really do something about this. And again, an amendment I put forward at committee stage on this bill in the House would do that. The government has not accepted it. I would implore the government to look again at that when it comes back to the House of Commons. And a driving ban, in many cases, can be a more appropriate punishment than locking somebody in prison. Prison isn't always an appropriate punishment for somebody who doesn't actually pose any danger to the public, except when they're on the roads. But we do not use driving bans nearly enough in this country, and we don't have long enough bans when they are used. The government is in real danger, I would suggest, of missing an historic opportunity here by using this bill to address some of the dreadful injustices that we've heard about today, and many others that we haven't heard about. To be behind the wheel of a vehicle is to be in charge of a lethal weapon. And for far too long, our laws and courts have treated driving as a human right rather than a privilege to be earned and, if needed for others' safety, to be taken away. And I do hope the government will think again about this and not squander this opportunity.
Jim Shannon.
Thank you, Mr. Rossendale. As I say, it was a pleasure to speak on this, because it is a pleasure to speak on it. But it's also a very motive one, as other honourable and right honourable members have referred to. And whenever we read the background, and I am very aware, Mr. Rossendale, of those in the gallery and the audience today who have experienced something that we're going to try and put forward their case in using words that hopefully will illustrate the issue for those people. And I think of an honourable friend to my right-hand side who spoke very personally about the case as well. I thank the Honourable Lady for Neath for setting the scene so very appropriately and so very well. That's deeply in the mood that it needs to be set, because I think that's important. And I want to begin by thanking the Petitions Committee for the opportunity, and to all those who took the time to sign the petition and allow us to debate what is a very worthy topic, and one that all members have spoken to. I recently read some documentation. I always, Mr. Rossendale, try to give an ordinary perspective of this debate because of what has happened as well, because it's replicated across the whole of this great nation, the United Kingdom of Great Britain and Northern Ireland. Some documentation from the Department of Infrastructure in Northern Ireland stated that over the last 5 years, 56 people have lost their lives here due to excessive speed, having regard to the conditions. Many, many more have been seriously injured, and every 1 mile per hour reduction in average speeds causes, on average, a 5% reduction in collisions. So there could, and there clearly is, it could be the difference between life and death. And for too many families, there will be an empty chair at the Christmas table this year. and a spot many hearts that will be forever feel empty. We can do all we can, Mr Rosendale, to fight against cancer, diabetes, against heart disease, things that are difficult to control, and yet deaths that are preventable that simply shouldn't have happened seem to be accepted. And that is the reason why we look to the Minister, as the Honourable Gentleman who spoke before from Exeter referred to. We look to the Minister for legislative change, because that's what we ask for, and that's what we hope this debate will achieve. The debate today highlights the preventable nature of some of these deaths and says it there, that where there was fault, such as someone checking their Snapchat on their phone on a repetitive method, as the Honourable Gentleman referred to, and where they drive on and make no effort to stop, there must be consequences. The Honourable Gentleman for Exeter has, in his past, tried to introduce legislation, and he referred to that. And I just want to say, Mr Rosendale, that I would support very much what the Honourable Gentleman has said, and I would challenge anyone in this hall today or outside of this hall not to feel that they could support that as well, because it's legislative change that is needed. It's legislative change that can make the difference, and that's why I think the Honourable Gentleman really summed it up very, very well. And the amendment that he's referred to would be appropriate and would be a substantial process in the right direction. When I read the premise of the debate, my heart ached for those families, and I want to sincerely express my sympathy, Mr Rosendale, to Matt, Paul and Ryan's families. I also want to express my admiration for the steps that have been taken to prevent other families from suffering this torment, from other families to be saved from knowing their loved one was hit and then abandoned. With examples of specific ones, but we know many others that have happened as well. I absolutely support the families in their efforts today to prevent other families from feeling this and to ensure that the message is clear. You cannot run away from an accident. You must face it, and you must take the consequences of that as well. We all know in this place, and when we legislate, the sentence should and will equate to seriousness. And I believe that we need to legislate more firmly for the message to be clear. And however, we do and must get the changes right. And I noted the briefing by Cycling UK, which stated, and again, I want to quote it in its entirety if I can, Mr Rosendale, in the short time that I wanted to speak. There are reasons to fear that government's overall legislative package could well prove counterproductive. And again, the Minister, in his reply at the end, can give us his thoughts on Cycling UK and what they say. And the reason why they say it's counterproductive is by creating a much stronger incentive for drivers facing prosecution for causing death to argue their driving was merely careless, therefore not dangerous, while simultaneously making it easier to do so by creating a new offence of causing serious injury by careless driving. The introduction of causing death by careless driving in 2008 led to roughly a halving in the number of prosecutions for causing death by dangerous driving, even though the definition of dangerous and careless driving had not changed. And they fear, and they say, we fear, and I have to say that I fear, the proposed new offence could have a similar effect. So again, Minister, with great respect, I think these are the questions that the families here need to have answers to, that we as right honourable and honourable members need to have. We're not putting you on the spot, Minister, but I really, really do beseech you to respond in the way that this debate and the mood of this debate, I think, would reflect the seriousness of the situation and the responsibility for government and for their Minister to respond in a way. I want to finish with this, Mr Rosendale. In my opinion, it is clear that any changes must ensure that prosecutors then have the ability to make the punishment fit the crime and not overcomplicate the system. And I look to the Minister, genuinely do, with respect, to outline how this debate and this House, and this debate today in Westminster Hall, can achieve this goal today. Too many lives gone, too much hurt, too much pain, and not enough acknowledgement in law, and that has to change. So I support the petition today, as the Honourable Lady for Neath put forward, but I also ask for meaningful legislative change to be the result of this difficult and emotionally draining debate we've had today. Thank you.
There'll be more.
Thank you, and it's a pleasure to serve under your chairmanship, Mr Rosendale, and I congratulate the Honourable Member for Neath for securing this important debate as a follow-on from the Petitions Committee. Before I start, I wanted to pay tribute to everyone that's lost their life and their families who are here today from these tragic circumstances. The issue of road safety and reckless driving is a huge problem in my constituency of Keighley and Ilkley. And I receive endless pieces of correspondence from my constituents who want to bring this issue to my attention. We often hear too often that Keighley streets are being used as a racetrack. And of course, the consequences of dangerous driving can be catastrophic. Reckless driving can prove fatal. So I welcome this debate to discuss the tragic consequences of reckless driving in my constituency and across the UK. And I'm afraid to say that such a fatal accident happened near Eastbourne, right on the boundary of my constituency, only a few months ago, which led to the tragic death of George Lewis, a 9-year-old boy. This was in a hit-and-run incident where the driver fled the scene, a 49-year-old man who later turned up at a police station and came forward and was arrested. But this 9-year-old boy died at the scene, and who he was with was also hit and injured. Earlier this year, there was another collision in my constituency just on the Addingham bypass, which sadly took the lives of 2 more people. These crashes were the result of reckless driving, dangerous driving. Instances like these ones, and indeed those mentioned by other members here during this debate, show the importance of addressing these issues and what offences are necessary following such fatal collisions. We must ensure that the offences for reckless driving are such that they do justice to any victims of such horrific incidents, as well as their families. Indeed, it can also help provide a proper deterrent to make people think more carefully about driving dangerously in our communities. The petitions we are debating here today call for both tougher sentences for hit-and-run drivers who cause death, as well as widening the definition of dangerous driving. And I wholeheartedly support both of these notions. To start, I do believe it is important to widen the definition of dangerous driving so that it includes failure to stop after involvement after a traffic accident. The fatal incident in Eastbourne, which I referred to earlier, was a hit-and-run incident. And it is right that those who leave the scene after being involved in a car crash must absolutely face tougher consequences. I do believe we must strengthen the sentences for those convicted of dangerous driving, so that it takes note of those who leave the scene after the crime, as well as failure to report the incident. After all, who would know what the consequences would be, or the better circumstances would prevail if a driver doesn't leave the scene and reports it straight away, where provision can get there quicker? In my mind, the current punishment, as has been referred to in this debate, of 6 months imprisonment or a fine is not strong enough, and this absolutely needs to change. It is paramount that we address this issue. Reckless driving is a huge problem in Keighley and Ilkley and across West Yorkshire, and as I've mentioned, this can lead to tragic results. Hit-and-run drivers are cowards, trying to flee responsibility. Cowards because they don't face up to the consequences of what they're causing. And justice is needed for the families of the victims, and strengthening both the definition of dangerous driving as well as the punishments for those who commit the worst crimes is absolutely essential. Ultimately, changes to the law will help prevent such tragic circumstances, and I stand with those who are campaigning to make this happen.
Thank you, Mr Rosendale. It's a pleasure to serve under your chairship in this very important debate. And I'd like to thank the Petitions Committee and particularly my honourable friend from Neath for her powerful speech introducing it. But also I want to thank the hundreds of thousands of people who have signed the petitions about which this debate is, and particularly the families of those who've come today, those in the gallery, and also my good friend, the member for Bootle, who was so brave to describe his tragedy here in this debate. It just, your experiences, the experiences of our constituents, bring home what an important issue this is. This is a cross-party issue. I co-chair the all-party parliamentary group on cycling and walking, and when we were still the all-party group for cycling in 2017, we did a report on justice and the legal system, and back then brought a number of recommendations about changing the law. And I have to say, some of these are already been incorporated subsequently, but more could be done, and I'll go on to that shortly. I also led a debate in Westminster Hall on this very topic 3 years ago this month, when we had a useful response from the then Minister for Transport, who did announce, or repeat his announcement, that the law was changing. And I do want to congratulate the government on the changes they have made in this respect, by increasing the maximum sentence for dangerous driving from 14 months to 14 years to a life sentence. 14 months? Months. Years, sorry. 14 years to a life sentence. I'm sorry, I can't read my scribbles. And also increasing the sentence for careless driving while under the influence of drugs or alcohol from 14 years to life. And for those, we thank the government. And they've also brought in a new offence of causing serious injury by careless driving with a maximum 2 years, I believe. I also want to congratulate what the government have done in terms of encouraging more people to cycle and walk using the COVID emergency legislation, and they bringing in funding and regulatory change that makes it safer to walk and cycle in those areas where the local authorities have used that funding and regulatory change to create more space for cycling in particular. We won't get more people cycling, though, until or unless the conditions of the road feel safe, but truly are safe. And the same also goes for motorcyclists, who are among the proportionately highest number of victims of road traffic incidents. I also want to thank the government on the revisions to the Highway Code, because they've brought in what a lot of organisations who represent vulnerable road users in, by having a hierarchy of road users. So there is an expectation that the vehicle driver generally, who is driving a potentially dangerous metal can of several tons weight at speed at people on bikes, motorbikes, walking, in buggies and so on. So that is good. However, we do need to see the messaging on that brought out, because I don't think most drivers are actually aware of those changes, and that needs to happen, possibly even most police officers as well. So I would also like to thank the organisations who've briefed members today: Living Streets, British Cycling, Cycling UK and the Road Danger Reduction Forum for the very useful briefing and statistics that bring home the importance of this issue. And as I say, every time road safety has been discussed in this House, members from across both sides of the House, from all parties, have, as the member opposite described in his constituency in Keighley, and other members here today from Cornwall, from Exeter, from Northern Ireland, we've all got experiences where justice has not been done for the victims of road traffic collisions and their families, and there is still more work to do to get that to change. So what still needs to happen in terms of the police bill going through Parliament at the moment, and we thank the members of the Lords who've taken some amendments forward, and I thank my right honourable friend from Exeter for his amendment when this was in this House. And we need to bring these things back again. But we need to be specific. We need to clarify the distinction between careless and dangerous driving. So that careless or inconsiderate, if it involves a breach of the highway code that causes inconvenience, intimidation or danger to another road user. And it should be dangerous where a breach would lead to a driver being failed automatically if they drove in that way during a driving test. We need to ensure the maximum custodial sentences for causing serious injury and do not fall vastly below those for causing death by equally bad driving, while strengthening the role of driving bans for offenders whose driving has clearly caused danger but who are not obviously dangerous persons. And we've had examples today of some people who are clearly dangerous, repeated offenders, again and again. And those people need to be imprisoned to ensure public protection. But as other honourable members have said today, and right honourable members have said today, there are people for whom a driving ban would be sufficient punishment because they're not otherwise dangerous people. We need to strengthen penalties for those who continue to drive while banned and align the offences and penalties for causing death and causing serious injury while under the influence of drink or drugs more closely with those for causing death and causing serious injury while driving while disqualified, along with a new offence for causing serious injury while under the influence with a maximum sentence of 5 years, and increase the maximum sentence for opening the doors of vehicles in a manner that results in death or serious injury to 2 years. A woman died in my constituency many years ago on Chiswick High Road in just that situation. I also want to go on to another point that I don't think has been mentioned today, but I remember we raised back in our inquiry back in 2017, and that is the number of people who get off a ban when they should, at 12 points or more than 12 points, be automatically banned, or when they're served with a ban and successfully appeal. If you make the same analogy with somebody who'd been a serious house burglar or had assaulted somebody in the street, they don't get off their sentences because they need to go to work or they need to look after their children. So why should somebody who causes serious injury through dangerous or careless driving be let off a driving ban? So I agree that a driving ban should be used more, but it should be imposed more by the judicial system. So, Mr. Rosendale, safer roads mean more people will walk and cycle. That will reduce congestion, increase health, reduce pollution and improve the economy because vehicles that need to be on the road can get there faster. Our sympathy has to be with all those who've lost a loved one through death by dangerous driving. How we can do something about that sympathy, more than just words, what we can do in this place to strengthen the law. Thank you.
Tahir Ali.
Thank you, Mr. Rosendale, and it is a pleasure to serve under your chairmanship. Last Thursday, in my constituency, a 3-year-old girl crossing a zebra crossing was killed by a hit-and-run driver who fled the scene and was arrested later, a 24-year-old man. On the Sunday, August 29th, this year, my immediate neighbour, a bus driver, 61 years old, was walking to work, and he was struck by a car that was stolen, false plates, driven by a 20-year-old. Last week, he got a sentence of 3 years and 8 months. My neighbour did not need to go to work that day. He only went to work because the money he earned on a Sunday, he donated entirely to charity. Ghulam Nabi, 61-year-old. Dangerously driven car, stolen, no insurance. The driver fled the scene. it was only after police released the CCTV images that he handed himself in. I believe, had that not happened, he would have never handed himself in. But if you look at the crime that has been committed, if you look at the sentence that's been given, there is no comparison. 3-year-old girl with a mother crossing a zebra crossing last Thursday on Reddings Lane in Tyseley, my constituency, has given her life to another reckless driver. At what point do we say enough is enough? These tragedies are some of the examples of the fatalities due to reckless driving in the UK, a problem which is a growing concern, not only for my constituents, but every constituency across the UK. And both of these examples, the drivers fled from the scene, failing to demonstrate any concern for the victims. Such callous behaviour warrants serious punishment under the law. Measures need to be brought forward to help stem the rise in reckless driving. Every year, road traffic accidents claim over 1,700 lives, with many more injured. Imagine 1,700 lives being taken. In another way, it would be uproar. That is more than 30 to 35 lives being taken on a daily basis. Yet, we do not seem to have the punishment that match the crime. But equally, I believe more resources need to be given to the councils so the street scene can be adopted in a way where it is safe for the pedestrians, where it is safe for the children, it is safe for cyclists, and the motorists automatically reduce their speeds. If measures are not provided where we cannot provide 24-hour policing on these roads, there's got to be a street scene issue that needs to be addressed, and it needs to be addressed urgently, and that can only be done by government providing resources to the councils. And also then punishing the culprits of these callous and senseless acts where they flee the scene and have no remorse for the actions that they have taken. Not only measures must be brought in to encourage safer driving, tougher measures need to be brought in, but the repercussions of killing someone through reckless driving at the moment are nowhere near adequate. Sentencing for hit-and-run drivers must be toughened, and the offence of causing death by dangerous driving should be widened, in my view, to include failure to stop, call 999 and render aid on scene until further help arrives. So it's a plea from everyone in this room, and there is not a single contribution that I can disagree with, whether it's the constituents in Keighley or any other constituency which has been mentioned today, and those that have not been able to make it here to put the cases forward. So, Chair, it is a plea to the Minister that this needs to be addressed with seriousness, and it will receive support from all sides of the House. Thank you.
Chris Stevens.
Well, thank you, Mr Rosendale. It's a pleasure, as always, to see you in the chair. And I'm sure you would agree with me that what we've heard today is a debate which is the best traditions of the House, a powerful and emotional debate, and I think first-class arguments being used by honourable members who have raised the issues so far. And I want to say that my heart certainly goes out to those in the public gallery, and of course my good friend who represents Bootle, for the most tragic circumstances that they've found themselves in, because that's what the petitions before us today deal with, is those most tragic of circumstances. It's really difficult to imagine how hard it must be to deal with the grief of losing a child or sibling in this way and still feel that justice has not been served. Because it's the concept of justice that's the heart of these petitions. Now, it's perfectly acceptable for all of us to have differing opinions on what justice is. For some, it's the right punishment for those who have committed a harm to another. For others, it's a chance to get answers and to hear an explanation or an apology. It can, of course, be a combination of both, but the fundamental principle lies in the perpetrator of the crime being held to account. And the understandable frustration in the petitions before us today arise from the feelings that neither of these concepts are fulfilled when a person flees the scene of an incident. The Road Traffic Act 1988, as we've heard, deals with failing to stop or report an accident and dangerous and careless driving offences. The two fundamental sections engaged in incidents of hit and run. As both petitions suggest, there is a gulf of disparity between the sentencing guidelines for failure to stop after an incident and for death by dangerous or careless driving. And as we've heard, the former being a maximum 6-month custodial sentence and the latter being between 5 to 14 years custodial sentence. The Government have reiterated in their responses to the petition that failure to stop offences are more often than not low-level traffic incidents such as the clipping of a mirror, the scuffling of a bumper in a car park, for example. However, on occasions where the failure to stop or report relates to an incident which leads to the death or serious injury of another person, then this can be an aggravating factor in the sentencing decisions. The question before us today, Mr Rosendale, is whether that is good enough. And that's a question that's gathered interest over recent years, as honourable members have said, with the police crime sentencing and courts consultation firstly, and then the amendments tabled by the right honourable member for Exeter, which would have seen a new offence of failing to stop or report accidents where the driver knew that the accident had caused serious or fatal injury, or where they ought reasonably to have realised that it might have done so. And I hope the Government will consider the right honourable member for Exeter's amendment during the bill. He will certainly have my support in that, as he does with many others in the House today. It's the disparity in the sentencing for failure to stop death or serious injury by careless or dangerous driving that's led to honourable members today suggesting that there is a perverse incentive for people to flee the scene of an accident. And this has been heard before and again today, where, as honourable members have explained, that if a driver under the influence of drink or drugs kills someone and remains at the scene, the likelihood is that they'll be tested, charged and prosecuted for that offence. However, if they flee the scene and have time to sober up, and there is no other evidence of careless or dangerous driving, then they can only be prosecuted for the minor offence of failing to stop or report an accident. And that is something that we really must deal with going forward. Now, Mr Rosendale, just 2 months ago, on the 11th of September, 18-year-old Aidan Pilkington was struck by a car and killed on Crow Road in Glasgow. The driver of the car fled the scene. Aidan was about to move to Dundee to attend university, and he was so well loved by his friends that they kept a daily vigil at the spot Aidan was killed for over 3 weeks. To date, there has still not been an arrest made, and the driver, whoever they are, remains out there on the roads in the knowledge that at 2 a.m. on the 11th of September, they struck a bright, well-loved young man and ended his life. Could it be that the driver was either under the influence of alcohol or drugs, or was driving a vehicle they had no right to be in? And that is something that we really need to deal with going forward, and I have the support of honourable members who are seeking a change in the law. Now, Mr Rosendale, the Scottish Government and Police Scotland are committed to reducing roads death by half over the next 10 years. This is an ambitious target, but it's commitments like this that are required to make our roads safer for us all. Deaths and serious injuries caused on our roads can often be prevented, and it is our duty to ensure that we do all we can to improve driver behaviour and educate road users. The new Road Safety Framework in Scotland sets out a vision for Scotland to have the best performance in road safety in the world by 2030. And so in closing, Mr Rosendale, while these measures go no way to achieving justice for the families who have tabled these petitions, what's happening in Scotland may go some way to ensuring we prevent tragedies like these before they happen. And I look forward to hearing from the Minister and how the Government is looking at education, improving driving behaviour and answering the calls for tougher sentencing and new laws to address the points raised in these petitions. Thank you.
Harry McCarthy.
Thank you, Mr Rosendale. A pleasure to see you in the chair, as always. I'm very pleased that the Petitions Committee has managed to secure a slot for this important debate fittingly at the start of Road Traffic Week. I hope that we have been able to do some justice to the topic this afternoon for the sake of the families and friends of victims of driving offences, and in particular to the families and friends of Matt, Paul and Ryan, some of whom are here today. I do want to congratulate the Honourable Member for Neath for such a thorough exposition of the reasons behind this petition, the reasons why a change in the law is needed, and for going further and meeting the families and friends. I think it's really important, and I say this as a former member of the Petitions Committee, that we do justice to the petitioners, which isn't always the case in these debates. And as I say, I hope that they do feel that we're at least speaking up for them today. It can't have been easy for them to relive their personal tragedies in pursuing this petition, but I do understand why they felt compelled to do so, to try to ensure that others didn't have to go through the same hellish experience. And the Honourable Member for Neath commended their courage and tenacity, and I would like to do the same. Some people might recall the case of Kevin Duggan, who was killed in 1998 by a drink driver. And his father, Declan, who happens to be, if you grew up in Luton like I do, everyone knows the Duggans. There's an awful lot of them, big Irish family. Declan campaigned for the law to be changed 4 years later to give doctors the right to take blood samples from unconscious drivers, because in the case of Kevin, they weren't able to do so. So that just shows that tenacity and campaigning, of which he had huge amounts of tenacity, does pay off, and I would urge the petitioners to continue. Because we do have to do better than this. As we've heard today, far too many lives are being lost in road traffic accidents. In far too many cases, drink driving is involved. In 2019, it was estimated that between 210 and 250 people were killed in accidents in Great Britain, where at least one driver was over the drink drive limits. And I would like to assure the petitioners that, as the Labour spokesperson, road safety is a priority for us. We've supported increasing the maximum penalties for offences of causing death by dangerous driving and causing death by careless driving while under the influence of drink and drugs, from 14 years imprisonment to imprisonment for life. We've also supported the introduction of a new offence of causing serious injury by careless or inconsiderate driving, fixing a gap left by previous legislation which would set the maximum penalty for the offence on indictment at 2 years imprisonment. I don't want to dwell too much on the contributions that were made by others speaking today, because I think it's really important we allow the Minister time to speak. So rather than reiterating some of the very specific asks from the petitioners, and particularly from Cycling UK, which I think the Honourable Members for the Right Honourable Member for Exeter and the Honourable Member for Brentwood and Isleworth more than did justice to, I want to just ask about the full review of the road traffic offences framework that was promised back in 2014 but never happened. I have pressed ministers on this. They failed to provide a time frame for a review. So can the Minister clarify whether the review will still go ahead and when? As the Honourable Member for Neath said, the time to do it is now. There can be no excuse for further delay. And unfortunately, at the moment, what we're seeing is when it comes to road safety, the government is steering us in the wrong direction. Last week, the DFT brought forward changes to driving tests, including the removal of the requirement to take a separate test to tow a trailer. And my honourable friend, the member for Bristol South, has campaigned on this after the death of a young child in her constituency. Labour recognises the urgency of the need to expand testing capacity in light of the HGV driver shortages and the consequent damage to UK supply chains, but we are concerned at the safety implications of these changes and believe that if they do go ahead, they should be temporary in nature. We've also seen a damning report in the last week or so from the Transport Select Committee on smart motorways. The Shadow Transport Secretary and I have met with the families of some of those involved with deaths attributable to the lack of a hard shoulder. And it's clear that the botched rollout should be paused until appropriate safety measures are in place so that no other families have to go through the grief that they've experienced. Lastly, as we've heard, cyclists are especially vulnerable road users. I won't go into detail of that, but cycling campaigners have raised concerns about the lack of deterrent for drivers fleeing the scene after collisions with cyclists, the inadequacy of sentencing for car dooring offences, the ability of drivers to defend their actions by labelling them careless rather than dangerous. So I hope the Minister can address those concerns and can set out what consideration both the DfT, the Ministry of Justice, the Attorney General's Office have given to strengthening legal protections. I'd particularly like to know what recent discussions have taken place between the Department for Transport and the other departments I mentioned. I know that there will be many victims of driving offences listening closely to the Minister's response today, so I hope the Minister can offer some assurances that this is a priority for the Government, because at the moment, as we mark Road Safety Week, it doesn't appear that it is.
I call the Minister to reply to the debate. Andrew Stephenson.
Thank you, Mr Rosendale. It's a pleasure to serve under your chairmanship. And can I start by thanking the Honourable Member for Neath for opening the debate on e-petitions on road traffic offences for fatal collisions, raising specific concerns about the current failure of the stop and report offence. Can I also start by paying tribute to all the Honourable and Right Honourable members who have spoken with such passion about families in their own constituencies and families across the UK, many who have been fighting for some period of time for justice following what has happened to loved ones. Can I especially thank the Honourable Member for Bootle, who spoke movingly about the death of his own daughter. Let me first start by reassuring all Honourable and Right Honourable members that the Government takes road safety very seriously. It is at the core of the work of the Department of Transport, and especially at a time when we are working so hard to boost walking and cycling across the UK, and many of the cases referred to, of course, tragically have involved pedestrians or cyclists.
Would my honourable friend be
Yeah, I will.
Over 1,000 people in my constituency of Lee in Lancashire have signed the petition on Ryan's Law. Can he give them, and I ask him directly, assurances that the department is looking at both clarifying and strengthening the law on this matter?
Well, I thank my honourable friend, the member for Lee, for that point. I hope he will bear with me as I come to some more detail on that. But I know the strength of feeling in my own constituency on this point, where, again, dangerous driving, as many members have said across this House, is a top concern for many residents that I represent. Let me be clear, any death or serious injury on our roads is unacceptable, and our deep condolences go to the victims and to their families. My ministerial colleague, the Roads Minister, Baroness Vera of Norbiton, has met with some of the families of victims of similar incidents, and with MPs campaigning for their constituents, including, as referred to before, my honourable friends, the member for North Cornwall, North Warwickshire, and the honourable member for Truro and Falmouth. We understand the tragic circumstances that have led to these e-petitions that we are debating today, and the concerns that have been raised that in some cases perhaps something is not working with the law as it currently stands. Whilst we must do all we can to improve the safety of our roads, we must also be careful and make sure that we do not make any rash decisions that could ultimately make things worse or create other unseen effects in a rush to resolve problems with the law and how it currently operates. So let me start by turning to the current offence of failure to stop and report. In the case of failure to stop and report, we know that in a small number of cases, the failure to stop may be related to an event which leads to death or serious injury to another person. But we must not forget that in the vast majority of cases, failure to stop convictions involve low-level traffic incidents, such as hitting a wing mirror on a narrow street. It is only in an extremely small number of cases that there may not be any other evidence to connect the death or serious harm with the driver who fails to stop, meaning the only offence they have committed is that of failure to stop and report. I understand the concerns that have been raised about this today and have previously been brought to the attention of my department. However, increasing the maximum sentence for failing to stop and report, even in a limited scope where there has been a serious or fatal injury, cuts across the basis for that offence. I must stress that the offence of failure to stop and report is designed to deal with the behaviour relating to the failure to stop. The offence is not provided as an alternative route to punish an offender for a more serious but unproven offence. Increasing the custodial sentence so that it is comparable to sentences for causing death by careless or dangerous driving, or including it in one of those offences, would represent a massive uplift in the potential sentence. For an offence that, I must remind honourable members, would be one where there is no requirement for evidence for a causal link between the failure to stop and the death or serious injury. It must be remembered that where there is evidence that a driver has caused harm, there are already a range of other offences, including causing death by serious injury or dangerous or careless driving, with which the driver can be charged. In these cases, the courts can treat the failure to stop as a factor that adds to the overall seriousness of the offending. This can result in the offender receiving a higher sentence. Where there is evidence that the driver knew about the incident and took steps to avoid detection, then they can be charged with perverting the course of justice, a common law offence that already carries a maximum sentence of life imprisonment.
Does the Minister have any details of how often that has actually been invoked? I mean, it's one thing to say that they could be charged with perverting the course of justice. Does that actually ever happen?
It's unwise for ministers to comment on Crown Prosecution Service kind of sentencing, prosecutorial decisions or judicial decisions. I know I was reading this week a case just outside my own constituency of somebody who there was a failure to stop and they had been charged with death by dangerous driving. I think in this area we need to, and I'm going to come to this point if she will allow me, I think we need to look at the suite of available options that there are for the charging authorities, and also to ensure that this is the most effective way possible. What I'm saying in this point is that just simply strengthening the failure to stop and report offence may not be the most effective way of ensuring the justice that I know many families are seeking to achieve.
Yeah, I thank the Minister for giving way. But I think the concern that the petitioners have, and honourable members in the House have, is the perverse incentive for people to flee the scene. So should there not be a new charge of failing to stop following a fatal or serious injury?
So this is something that the Department has been looking at, and I know Baroness Veer, my noble friend, the Roads Minister, has been talking to families about. One thing that we are very keen to see is more evidence on the reasons behind failures to stop and report in such serious incidents. It is clear, as I said, the majority of incidents that are treated as a failure to stop and report are low-level motoring incidents. However, in the most serious cases, we need to gain more evidence as to why that is the case. We have heard many drivers in some of the cases cited today who have said that they feel they've hit a fox or a deer, or various other people have panicked. There have been a range of justifications used, whether they are true justifications or not. I think it's important that we understand that more. I know the University of Leicester carried out some research on this in 2017 on behalf of the Motors Insurance Bureau, but again we have to build this evidence base to ensure that whatever we do in terms of reforming these offences is something that doesn't have unintended consequences and actually strengthens the law and gets the families justice that they deserve. Linking death or serious injury with a failure to stop as a cause, however well-intentioned, could risk creating unnecessarily and unfairly severe offence. The law already imposes severe penalties for vehicle owners that cause death or serious injury, but when doing so, a clear causal link needs to be provided between the driver's behaviour and the outcome. The proposals in the e-petitions would essentially be equating the seriousness of failure to stop with the actual culpability for causing death or injury. That, and as I've said, but I want to repeat, creates serious anomalies with other offences that could result in potential injustices. However, I want to be clear today that the Government is not dismissing the concerns that have been raised. We are aware of the traumatic effects of such incidents, which we have heard so eloquently expressed by members across the House from all parties today. We agree that there might be something wrong with the law as it stands, and it may not be working as well as it should in this area. I'm sure honourable and right honourable members will appreciate from what I've already said that this is a very complex area, and any change in the law should fit within the current driving offence framework. Officials from my department have been exploring options that could be pursued in this area. This includes, but is not limited to, the available penalties, how the offence operates, how this offence is dealt with in the sentencing guidance, and the potential for a new offence as part of a longer-term and wider approach to road safety. I'm sure officials will consider the points raised by members across the House in the debate today as part of their considerations of that offence. As the next step, the Department is considering conducting a call for evidence on parts of the Road Traffic Act. Although details are still being fully worked on, this would, I very much expect, include failures to stop and report as an offence. In closing, can I just thank honourable and right honourable members across the House for the points they have made in today's debate. Happy to give them.
Could you possibly address this question of where the full review of offences and penalties is? Is that what he was talking about? Because he seems to be suggesting a call for evidence on just a few areas. But we were promised a full review. And if you could say something about the use of exemptions as well to get off bans, is that involved in this call for evidence? Because that's a really egregious problem.
So, as the right honourable gentleman said, the Government committed to carry out this review of the road traffic offences back in 2014. A review of the most serious offences was carried out in 2017, as he will be aware. The outcome of that review has fed into the measures that we're bringing forward as part of the police crime sentencing and courts bill that was referred to by a number of honourable members. My noble friend, the Baroness Veer of Norbiton, the Road Minister, is looking at that and seeing how we can potentially go further. And that further call for evidence would be seeking to build on those measures that we have already identified and bringing forward as part of the bill. So that would be in addition to the steps we have already taken. With that, Mr Rosendale, can I just thank once again honourable and right honourable members for what they have said. Their contributions are being listened to by not just officials in the Department of Transport, but officials across government. This is an area we have to get right. And can I especially pay tribute to the families who have come down here and taken the time to share their stories with honourable and right honourable members. Thank you.
Christina Rees to wind up.
Thank you, Mr. Rosendale. Thank you, Mr. Rosendale. I thank all right honourable and honourable members for their valuable and emotive contributions to this very important debate. The Minister has heard agreement that road traffic offences and sentencing for fatal collisions needs to be fully reviewed and changed now to strengthen sentences and close the loophole that allows drivers to run away after hitting and causing serious or fatal injuries to escape punishment. The Minister is a magnanimous man, and I appreciate that, as he says, his government is taking it seriously, as it should. But please, no more warm words or delays. We need change now. Justice must be done for victims and their families. It's been an honour and privilege to meet the petitioners and represent them in this debate. I urge the Minister to meet the petitioners and listen to them directly. They must be heard. Thank you.
The question is that this House has considered E-petitions 323926 and 575620, relating to road traffic offences for fatal collisions? As many as are of that opinion say aye. To the contrary, no. I think the ayes have it. The ayes have it. Order, order.